Appellate District of Ohio with the Honorable Beth Myers presiding, is now session.
Good morning, everybody. Welcome to the First District Court of Appeals. We have 3 cases on our docket to be argued this morning. The first case is Moxon versus Conversion Properties. Counsel, if you will both approach to the appropriate tables. Appellant over here, appellee over here. Mr. Powell, I understand you'll be arguing this morning on behalf of appellant. Mr. Rapier, I understand you'll be on behalf of appellee. Mr. Powell, you'll have 15 minutes this morning. Would you like to reserve any time for rebuttal?
Yes, Your Honor, 5 minutes.
All right, I will keep your time. Whenever you're ready, you may begin.
May it please the court, counselor, my name is Jonathan Powell and I represent the plaintiff appellants in this appeal. This is an appeal from the trial court's decision granting summary judgment for the defendants. This decision was rendered on January 26, 2022. A notice of appeal was duly filed on February 23rd, 2022. A little bit about this case. Alex and Simon Moxon were real estate agents who became employed to sell and or lease apartments and condominiums belonging to Mayfair of Montgomery, and this was owned by Conversion Properties. On April 21st, 2011, Conversion entered into a written agreement with Owner Lane Properties, who was the broker. Said agreement was extended until December 31st, 2014, and a written extension. The claims of Alex and Simon Moxon were dismissed. We have no quarrel with that decision. However, the claims of Owner Lane dismissed on 2305.07C, we do have an issue with. In its decision, the trial court based its grant of summary judgment on the statute of limitations found in 2305.07, as I just said, which is a statute for contracts not in writing, and the specific subsection is subsection C. So the suit was filed on November 30th of 2020. On page 3 of the decision, the trial court based its decision specifically on 2305.07C and even block quoted it. It next states that the invoices were dated more than 6 years and dismisses the action. In the complaint, in the answer, defendants admitted in their answer that this contract was in writing and that the contract was extended to December 31st, 2014. This is in complaint, paragraphs 9 through 11, and the answer, paragraphs 9 through 11. The written contract is governed not by 2305.07, but by 2305.06. The statute at the time the lawsuit was commenced in this matter provided for an 8-year statute of limitations. There was an amendment of 2305.06, which took place after the suit was filed, and does not affect the statute of limitations of 8 years.
Let me ask you, sir, it sounds like appellee agrees with you that the trial court applied the wrong statute of limitations, but they're arguing that the granting of the summary judgment should be affirmed on other grounds. Can you address that for me?
Yes, it appears that he's addressing an evidentiary record, and 56C, Rule 56C does take into consideration written admissions. So that's why I stated in the complaint, there was in paragraphs 9 through 11, there was allegations that there was a written contract that was that was the 2011 agreement, and then there was another paragraph alleging that this was extended to December 31st, 2014, and both of them were attached to the complaint. And the answer, it was admitted as such. So, in addition, so June 16, 2021, after the lawsuit was commenced, that was when the amendment happened to the 8-year statute of limitations. So since that was not really argued in their response brief, because 56C does include written admissions to be considered in the evidentiary record, there was an admission as such to those being a written contract, and therefore 2305.06 governs, and the 8-year statute of limitations should be applied in this case, and it was not. And if it was applied, then there were invoices included that are within that statute of limitations of 8 years that should have been taken into consideration before the trial court made its decision. That's all I have.
All right, you will have 10 minutes left for rebuttal if you need it.
Thank you.
Mr. Rapier, you will have 15 minutes.
Thank you, Your Honor.
I do concede that the wrong statute of limitations was applied. Our argument in response is that this trial court looks and reviews this de novo. And when you review de novo, the evidence before the court, there were invoicing, but the invoicing were just blank invoicing. Some didn't even have dates on them. So they weren't interpreted by affidavit. It's unclear what units they were applied to. So our argument is, even if we were to refer this back to the trial court will come to the same conclusion. And the trial court in its entry alluded to the same. In the very first page of the decision, it says plaintiffs failed to allege sufficient facts to establish liability upon the individual defendants. I think on the very...
On the individual defendants.
Yes. And what I'm saying is the court was looking at what the evidence before it at that time. And then on the very last...
Well, isn't there a difference, though, between the individual defendants and the corporate defendants?
Absolutely. And I know we're solely here for the corporate defendants. I think they conceded that, so that issue is now moved. But on page 4 of the decision, plaintiff fails to provide the court with any evidentiary support that any of the alleged commissions that are due and owing were earned within the 6-year statute of limitations. The court doesn't go and specifically say, you failed to comply with Civil Rule 56. But our argument is, if you refer it back, that's exactly where we're going to be.
Did you make that argument at the
I
time
did.
of summary judgment?
I did, Your Honor. I filed for summary judgment first. They countered with summary judgment, and then in our reply brief, we pointed out specifically the parameters of Civil Rule 56. I think their argument is, well, you attached to your summary judgment the admissions and interrogatories, but our argument within the briefs themselves were, here's all that we've received in discovery. The plaintiff has never told us specifically what commissions are due to each specific unit, interpreted the invoicing, interpreted a voluminous amount of records, and it's impossible for the trial court to determine liability. It's impossible for the defendants to determine what the argument was.
Isn't it more reasonable to interpret that sentence of the court's entry to say, I find that there are commissions potentially being owed, but none of them are within the 6-year period?
Absolutely, Your Honor.
But they might be within the 8-year period.
Might be within the 8-year period. But the court itself, I wish the court would have gave a little more detailed. Perhaps this was my fault for not being as detailed in my reply brief as I should have. There was nothing before the court to even discern what the commissions were related to. There were multiple units, and the core issue in this case is there's a contract. If they lease a unit, then commissions are due and owing. But the core issue that we argued at the trial level is, well, what happens if that tenant moves out? What happens if that unit is sold? Commissions don't run into perpetuity. That's why we're at such a large amount. $70,000 is what was.
So is the issue that you can't determine the amount of commissions, or you can't determine whether commissions are due at all?
Okay. Two core issues. One, if we referred back to the court, it even exceeds the 8-year statute of limitations. It goes back in time. But all of the invoicing, they would just send an invoice to say, you owe us this commission. And the response would be, based on what? That unit is no longer leased. And there was this back and forth. That wasn't really argued or brought to the forefront.
But there's an
of the
issue
trial
of
court.
fact, isn't there an issue of fact whether their commissions are due at all?
No, we put before the court, make them prove their case. They are the plaintiff. What commissions are due and owing? And their response was just to attach invoicing and records with no interpretation whatsoever. And that's what I'm arguing. If we go back to the trial court will relook at the evidence, as this court does de novo, and arrive at the same decision that they didn't comply with Civil Rule 56.
And when you say they didn't comply with 56, are you also saying that they didn't properly authenticate the invoices
Yes.
by affidavit or otherwise,
Yes, Your Honor.
deposition?
That's exactly what my argument is. There was a stack of records, I will say, that was attached, and those records were briefly argued, I believe, by the trial counsel, plaintiff's trial counsel within the body. There was no authentication, no evidence.
Just stapled to the motion?
Stapled to the motion. And our argument is, if we refer back to the trial court will look at everything, as you will, de novo, and arrive at the same decision. So it's harmless error. Thank you.
Thank you. Mr. Powell, you have 10 minutes remaining. And if you would, will you start where Mr. Rapier left off, and that is, was there properly authenticated evidence that the trial court could consider under Rule 56 on the merits if the trial court had gotten to the merits?
It does not appear that there's proper authentication for those.
So what do we do with that?
Well, we look to, the trial court didn't make a determination on that matter. They strictly looked at the statute of limitations, decided that because there was nothing within the 6-year period that was the basis of their decision. Now, they do reference in the decision that invoices presented to the court by the plaintiffs are dated October 2012, March 16, 2012, and February 2013, which does fall within the 8-year statute of limitations. And also, the defendant's motion for summary judgment as Exhibit 1 has all of these invoices that do include invoices that are within the 8-year statute of limitation.
Were those properly authenticated?
I'm not aware that they were properly authenticated.
So that gets me back, if we do a de novo review and the trial court maybe is right for the wrong reason, if we don't have any authentic evidence, what do we do with that if we're reviewing de novo?
Well, 5060 does include written admissions, which I would look back to the complaint paragraphs 9 through 11, which talk about a written agreement and an admission by the defendants as such, and that the 8-year statute of limitations should be applied. And if we do go back, there could be a possibility that the court doesn't apply the 6-year statute of limitations instead of the 8 versus 8-year, and addresses that issue of authentication at that point for those documents. But at the very least, it should survive a motion for summary judgment, inferring the facts and the standard that the motion for summary judgment presents.
Thank you. And that was my question. If you want to make other arguments, please feel free. You have some time remaining if you'd like to.
Your question allowed me to address that. Thank you.
All right. Thank you both for your arguments this morning. We will take this case under submission and give you a timely written opinion. Thank you all very much. The next case on our docket this morning is State versus Rogers. Mr. Gallagher is here on behalf of appellant. Mr. Cummins is here on behalf of appellee. Mr. Gallagher, you will have 15 minutes to argue this morning. Would you like to reserve any time in rebuttal?
I can reserve 3 minutes. I'd appreciate it. Thank you very much.
All right, and I will keep your time whenever you're ready.
Thank you. In this case, what you really have at best is an educated guess by Officer Schoenfeld. Not anything that he observed was he able to articulate in court there was a fact that would give rise to a reasonable suspicion.
Well, he articulated a bulge, right?
Correct.
And he articulated that your client was seen reaching into his vehicle
Yes.
and then putting something into his waistband.
Or appeared, what he said is appeared to. He didn't even conclude that he placed something in there. He said appeared. And one of the reasons why is because the car door at dusk from 180 feet away blocked him from the waist area, his hands and his pockets. So all he saw was below low legs and the upper body. And so all he could see was gestures. And there are a number of courts who have said a bulge is not enough. And that's really all you have.
So even if he were closer and he couldn't make out the actual gun,
Right.
and he just saw your client reach in, he saw him actually put something into his waistband, but he couldn't see it, and he saw a bulge, you're saying that's not enough?
That's correct. And I think even, in fact, one of the state cases that they cited to you was Taylor. And in Taylor, the 2 concurring opinions said this would all have been much different had the officer not seen the handle of a gun, but instead just saw a bulge. And that's a number of courts have already said that are cited in our briefs, which suggests the exact same thing. Looking and just seeing that bulge, while it may be a fact, cannot rise to the level of a reasonable suspicion. And everything else was just germane to the neighborhood. There was a block party with 2 people open carrying, which is legal, is not any indication of criminality. And it was at dusk where people could hide things. That's nothing specific to Mr. Rogers at all. The officer spoke about all the things he looks for that aren't in this case. Someone blading their body, someone trying to avoid eye contact. A number of the other cases cited by the state, which are all in the 8th District, talk about things like walking the other way, not responding when the officer calls out the name, doing a lot of other things. Their case, I think it was Higgins, was people handing a gun back and forth to one another, someone cupping it to hide it. None of that exists in this case. They didn't run the license plate to even find out anything about Mr. Rogers, so they knew nothing about him whatsoever. What they admitted in all of their testimony to 2 officers was, in essence, they were looking to see if they could confirm a hunch. They talked about stopping other people for the exact same reason, to see what was going on. What the officer said was, I saw something. He didn't even remember if he saw a bulge when the person came back, if it was even still there, if it could have been anything else.
Would you agree that if the officer saw a part of the gun, then there would be reasonable or articulable suspicion to stop?
I understand the case law is quite frankly, is a little bit against me in that regard, but quite frankly, the Sixth Circuit has also talked a little bit about this, which is the fact that you can carry conceal in Ohio with a permit. He may have been acting legally in that case.
Wasn't the Sixth Circuit case that you cited dealing with open carry?
It was.
And here we have like the old law and concealed carry. And that's what I'm trying to understand is basically if an officer believes that somebody has a gun concealed under the old law, they can just stop them to determine if they have a permit?
I question that. I really, really do. The First District has not ruled on it. A number of other districts have. And it was not the only reason, but said that it was sort of incumbent on the defendant upon stopping to prove that he had a valid reason to do that. That logic causes me to pause because then we're stopping people coming out of a liquor store that may appear young to see if they have an actual, if they're of age, or we can stop someone who's young looking and stop them to drive in a car to make sure that they're over 16, because if not, they may be engaged in what's legal. On appearances may be legal, just in case they're not, we're going to stop them to confirm that. I'm not necessarily sure is a proper extension of those cases. But I get what an officer might have to deal with, but there's nothing here that says that Mr. Rogers was in fact dangerous or anything else. They really wanted to just confirm their sort of educated guess on what that bulge may or may not have been. He had no furtive movements. He didn't do anything strange. In interacting with anybody, this was a block party, is what it was described as a block party.
What's your best case that says that an officer who observes a bulge it's not enough?
Excuse me, I apologize. I didn't used to need these things, but now I do.
Happens to the best of us.
I think as the Phillips case is the one, that's the Ohio Supreme Court, which talked bulging pockets do not connote criminal activity. That's 2003.
Okay.
And I
Is
think
a bulge in a pocket different than a bulge in a waistband?
I don't necessarily think so, because I think the question is what creates that bulge, and I think it's the willingness to accept innocent possibilities doesn't connote criminality. There is a difference, I think, in what Justice Krause talked about, which is at least the handle of a gun tells you I got a weapon. Here, you don't even have that. You're saying, I think I might have a weapon. I've seen weapons before, and maybe that's what the bulge is. He didn't even describe what the bulge is, which is one of the things some of the cases sort of talk about. Well, is it asymmetrical? He talks about the changing gait, or all these things that would indicate that you have something heavy, like a gun, in your waistband. Readjustment, any of those actions that might have led maybe to further based on his experience.
Well, plain devil's advocate, though, a pocket is likely to also contain keys, a wallet, things that you wouldn't find in a waistband.
Right.
Besides a gun, what else logically could be in a waistband? I suppose a
Pager.
water bottle.
Pager. Some people might do that. May have clipped on their phone. May have they didn't have a pocket and so push their phone in. I've seen kids pushing phones almost everywhere possible nowadays to go grab them. A person could be diabetic and there could be some sort of insulin monitor that's hooked on the waistband. They could be counting their steps and put a pedometer that isn't on the wrist and put it on their waistband under there. It could be a whole host of different sort of things. And I think just because he saw some bulge that he didn't see upon return. And remember, we're also talking about what he framed as less than a second from 180 feet away at dusk. And that also causes its own issues because he said he was turning away from him. So all he saw was, as he closed the door, walking away, turning his body, and that's it. That was it. That
Did he
was it.
testify he did not see the bulge on the way back, or he didn't
He
notice?
said he didn't look for it. Or
He
it
didn't
wasn't-
look for
he was-
it.
Or I think his statement was he was not aware of one upon his return. So,
Oh, okay.
so I will at least concede that either he wasn't paying attention or whatever. I will not state that the bulge wasn't there anymore. I don't think that's fair. But I do think that.
He didn't
if confirmed
specifically
it,
testify that he
I would have
saw.
expected him to say, I saw the same bulge coming back, because he took the time to say in his interactions with other people, what he did not see is any attempt to either hide whatever was in his waistband, get rid of it, or anything else like that, because he was looking for that. So I would expect at least he would have looked for confirmation upon return, and either somehow missed it or it wasn't there. But I'm not saying it wasn't there. No one else testified to that fact.
Mr. Geiger, in your brief, you argued the extension of the stop. Are you still arguing that? And if you are, I have a question for you about
Sure.
that.
Yes, sir.
All right, just assume for sake of argument, it was a good Terry stop,
Okay.
right? Doesn't the extension of the stop become academic at that point? I mean, if based on the articulable circumstances that the officer saw, doesn't it make the last part of your brief somewhat academic because of the extension of the stop? Because they were going to search the car anyway.
Well, that was an interesting sort of thing, because I almost think there's a tacit admission by that officer that they weren't quite sure what they had. I know he says we were going to search it anyway, but when they asked for him to get out and to search it, he said no, and they waited and said, okay, we'll have to get the dog and get the dog to alert in order to do a search. At that point, I think even the officer at that point is admitting, I don't think I have what I need, so I'm going to see if the dog can buttress my ability to get in the car. Because if they thought they had a dangerous person, they saw him without a gun and they think he has a gun, they allowed him to stay in the car.
Weren't his hands out the window the whole time, though?
No, they asked him to show his hands. And once they didn't see a gun, but you're still allowing someone in a gun. And the reason for the search is because a gun might be within arm's reach, right? Either under the seat, could be right next to him, could be still in that waist that was searched before. But they didn't. They at least at that point stepped down and had a belief that he didn't have a gun on him. But they wanted to search, but weren't sure if they could really get in the car because he said no to the consent. And they waited 9 minutes for a dog to go in there. Now, I know the state and everyone wants to say, don't pay any attention to the dog. But those cases still sort of apply, which is the detention beyond that which is necessary. And so they're at a standstill. They should have been able to just ask him to tell him to get out of the car. They have that right. Get out of the car. He says, no, you got problems. They could forcibly take him from the car. They didn't do that. They sat back and waited for the dog in order to do that. That extension of time case law, I still think, quite honestly, applies. I didn't get a chance to supplement it. I will. There's a Wood case out of the 5th District, I think, that came out within a week ago that says an officer changes from one point of view to another without justification, we got problems. I think in the Wood case, if I read it right, it was an officer watching trafficking, looking for drug people, saw a traffic violation, stopped the car for the traffic violation, and then stalled. Didn't do anything with the traffic ticket.
Well, in this case, there's no traffic violation.
I got that, but the point is, you're stopping someone for a reason and then changing the point of the reason around, or you're delaying the purpose of it. And in here, if the reason is to do we're an investigatory. We haven't even seen a crime yet. At best, we have the suspicion of a crime. We're not even to the level you've seen a traffic violation. So do you get to continue that investigative stop without doing anything and just sit there without taking any action? I don't think that's much different than sitting there with a traffic violator and saying, we're going to wait till the dog gets here. You're doing the exact sort of same thing. You have supposedly a gun investigation. You're not doing anything with the gun anymore. You're just waiting. And you're waiting. And
Yeah,
you're waiting.
but if this court would believe that it was a legit Terry stop because clearly the trial court believed the officer that he
Right.
believed there was a gun,
Right.
then necessarily they can search the car. Like, it doesn't matter that they delayed. I think that's what Judge Winkler's saying. He had his hands up and they could search the car whenever they wanted to search the car because they believed there was a gun in the car.
Well, I think that the question is whether or not you can really search in and into the glove compartment and whether or not they've already decided that he's not armed. I mean, those officers that were there didn't see anything that confirmed or gave them any rise to what was going on. They had a gentleman who was saying, I'm nervous, They saw him not doing anything. There's never a furtive movement to even mention. All he's saying is, you're making me extremely nervous, which is somewhat understandable. 6 officers, some not playing close. He gets a gun pointed at him. I'm not necessarily sure you're at a Terry stop right now. I think you've gone beyond a Terry stop. They may call it one, but they put stop sticks in front of the car. They approached with 6 officers, one at gunpoint, before even encountering him. Quite frankly, I'm suggesting to this court that I think the case law would also support that you're in an arrest situation right now. You're
And
beyond Terry.
You are at your time if you'd like to reserve 3
Okay,
minutes.
I appreciate it. Thank you so much.
All right, thank you. Mr. Cummins, you have 15 minutes.
Thank you, Your Honor. Your Honors, I think the search is an academic inquiry because they were going to be able to search because they had a reasonable suspicion that he was armed. And the case law about prolonging a stop pertains to traffic stops, traffic violations. That's not what we have here.
Did they explain why they bothered to ask for consent then, if they could search based on the Terry stop?
Yes, I think it's directly stated, and it's certainly, if you read between the lines, the defendant was scared to death. I think they could see that in his eyes. He was very upset. He looked like I think one of the officers said he was a deer caught in headlights looking straight ahead. I think they actually saw themselves in the role of de-escalating his nervousness and his tension. So they were trying to create a conversational attitude. Hey, you want to step out? How you want to consent to a search? You want to do that? And I think ultimately they said, well, we got a dog here that he's going to sniff on you at some point. Why don't you just let us come in? I think all this was more of a way to calm him down because they visibly perceived him as being very uptight, very nervous.
And why bother? I mean, so the dog was to calm him down? Because they eventually, I mean, they had to order him out of the car in order to have the dog go around the car, right?
I think the dog was already on the scene. I think they just kind of used that as a prop, as the third way to give him an option to make a decision to do something on his own. I don't think they wanted to force him out because it seemed like they were concerned that his demeanor and his nervousness was a potentially dangerous situation that could escalate. That's what I got from reading the record.
Did the dog alert?
I believe it did. I believe it indicated maybe on the side of the car. I'm not exactly sure.
Did they find drugs?
No, they
Oh,
found
okay.
a gun. But I guess what the defendant calls a hunch, the trial court found reasonable suspicion, and I think that is appropriate. The trial court here was very meticulous and very thorough in stating the factors that she found that demonstrated a reasonable suspicion. She listed them out, 5, 6, 7 factors that were valid. They were supported by evidence in the record. I think the fact that you don't have, one factor here or one factor there is certainly something I would argue if I was in their position. But the case law says we are to look at the totality. And if you look at the totality here, I think the trial court got it right. There was enough indicia of reasonable suspicion here that this man was armed, that it warranted what transpired.
But isn't the only circumstances that caused the officer to believe that he was armed is that he reached into the car and then reached into his waistband, or at least he thought he did, and he thought he saw a bulge, which he believed to be a gun.
Correct.
So based on that, you're saying that any time a police officer believes that somebody may be concealed carrying a gun, at least under the old law, they can just stop them to find out if they have a concealed carry permit?
No, I think you have to look at the totality of circumstances. They were deliberately called out to this particular area because it was a high crime area. A lot of gun violence had been reported there. The surveillance officer actually spotted 2 people at the block party openly carrying.
But let me stop you there.
Yeah.
That's okay. I mean, that was not a violation of law. How does that contribute to the likelihood that he might be carrying a weapon?
Well, again.
Because if I'm walking in a neighborhood and there are 2 people openly carrying, that doesn't make it more likely that I have a concealed weapon, does it?
Well, I think, it goes back to the totality of circumstances. And recall what the surveilling officer saw. He saw that the defendant parked his car and got out and started walking towards the party. And then he probably saw what the officers saw. Yeah, there's people here with guns. And he hesitated. He went back, reached into the compartment of his car, and he's got a bulge in his pants when he actually walks away. I think given that totality, I think the officer certainly has a reasonable suspicion that, yeah, he probably just reached and put a gun in his waistband.
But he didn't see the bulge on the way back to the car.
And he didn't say he didn't see it. He said it wasn't even something that registered. It wasn't something he was focused in on. And he admitted-
But that's like the whole point, right? They want to, I mean, he's there to tell other officers to stop him. You'd think that he would testify, well, yeah, that I saw the bulge on the way back. So that's how I knew it was a gun, because it's not like something that he got rid of.
Yeah, in a perfect scenario, he would have said, "You're darn right. I watched this guy come all the way back, and I still saw the bulge." For whatever reason, he said, I didn't think to look there. And we don't really have an explanation of why he didn't, but he candidly admitted he did not look there. He did say that I did not see him dispose of it anywhere. But again, I think that this is all part of the totality, and I think that the trial court here did a very thorough job, and I don't think that her decision here can be called clearly erroneous, such this would be reversed. I would note that I know the majority of this court in a juvenile case, JL or JC or something, reversed the admission of the gun because there wasn't a bulge. And that was one of the main factors that this court, the majority, thought, hey, if we saw a bulge or if a bulge had been testified to, this would be a game changer on that case. Here we have that. So I don't think it's a close call, but I think certainly with all the factors we do have, as thoroughly listed by the trial judge, I think this is certainly a solid decision, and we'd ask that it be affirmed.
Any other questions? Thank you.
Thank you very much.
Mr. Gallagher, you have 3 minutes remaining.
The officer's portrayal of what Mr. Rogers did was he had barely stepped out of the car when he turned to get back into it. So I'm not necessarily sure there were chances to surveil the area further up. It led to his actions. The officer didn't indicate that he even stopped to look. He says he stepped out of the car and began to turn back. There were 6 factors that the trial court listed out in terms of supporting an articulable reasonable suspicion. One was the high crime area. Second was 2 people open carrying, which is not a crime. Third was it was dark.
Let me back up because I'm the one who pointed that out. But Mr. Cummins had a good argument on why that might be relevant in the totality of the circumstances. That being, he saw somebody with guns and he wanted to be able to defend himself, so went back to get his gun.
That I get, but what the officer testified to in terms of the actions of Mr. Rogers sort of belie that. He talks about him sort of stepping out of the car and almost immediately turning around and doing something. So I'm not necessarily sure that anyone said that those were within his eyesight at the time, or he looked towards the crowd, and I think that might have been indicative of it. But it was dark out. And I don't necessarily know if that's an articulate system.
Well, it was dusk. Wasn't it dusk?
Well, what I'm saying, but the judge stated that you could hide something. I guess so. But the next 3 all just are about the officer. Is that the officer has experience was 4. 5, that the officer has knowledge. I'm sorry, that was 4. 5, the officer has knowledge. And then 6, the police officer saw something, which is what Schoenfeld said. He said he appeared, not conclusively, but appeared to be placing an item into his waistband. And what the officer did to stop said is individuals who are suspected to be armed, so we make stops to, ensure the validity of everything. And that's what it sounds like was going on, which is they're doing stops to ensure whether or not what they saw was in fact what they saw. Without truly a real belief of it, they just have these hunches or guesses based on the neighborhood that they're in and the people that are around there doing something that maybe causes them a second to say,
Just to ensure the validity, doesn't that mean to stop somebody they believe is concealed carrying to make sure they have a concealed carry license?
Well, he didn't say it that way, but he said suspected to be armed. And that's, it sounds like they're stopping some people, they said committed crime, because they clearly made a distinction. We saw some people committed crime, we stopped them. And then there's this other group that we stopped. And I think it's still just based on this educated sort of guess. It doesn't rise to the level of reasonable suspicion, but an educated guess of sitting back there, and they're just picking those other folks and seeing if they're right or wrong about those folks. The Sixth Circuit has said that there's no firearm exception to Terry, and they quote the U.S. Supreme Court in terms of Florida versus JL. You have the Wood decision I mentioned, but you also have, I think it's Neyhard, N-E-Y-H-A-R-D. We had filed a motion to supplement with that recent decision that talks about, I think is the trend about extending detentions without the probable cause or without the reason to do so.
And you are at your time, but I'm going to let you finish that thought.
I guess what I just want to say is, look, there's really no articulable facts specific to Mr. Rogers really on that day that would rise to the level to support the stop, detention, and then the eventual search in this case. And I'd ask this court to reverse the trial court and then send it back with instructions to grant the motion and proceed as it need to be. Thank you very much for your time.
Any other questions?
Right.
No.
And I
Thank you.
apologize, and I think it should at least be mentioned, my opponent is filling in and did so admirably, given the fact that I guess my listed opponent was sick and couldn't be in here. I think he's hoping I would submit it, but I just can't do that for Mr. Rogers, but I appreciate the time.
Thank you. We appreciate it. Mr. Cummings, we appreciate you filling in. Thank you both very much for your arguments this morning. We will take the case under submission and give you a timely written opinion. And the final case to be argued this morning is State versus Bailey. Ms. Nelson is here on behalf of appellant. Ms. Steer is here on behalf of appellee. Ms. Nelson, I know you know this, but you will have 15 minutes to argue this morning. Would you like to reserve any time in rebuttal?
5 minutes, please.
All right, I will keep your time whenever you're ready.
Good morning, Your Honors. Good morning, Ms. Steer. Sarah Nelson here on behalf of the appellant, Mr. Ryan Bailey, and may it please the court. The issue before the court this morning is whether Mr. Bailey was in custody, requiring the police to have provided the Miranda warnings prior to police questioning. In analyzing the in-custody question, the ultimate inquiry is whether a reasonable person would have understood that he was in custody at the time of question. Now, this case concerns a traffic stop, so generally speaking, an ordinary routine traffic stop does not rise to a level of a custodial interrogation, triggering Miranda under every circumstance. But that's not every single case. So we look to whether this particular driver, under the circumstances, was treated in such a way that he would believe that he was in custody. We believe the facts of this case do warrant such an in-custody determination.
Let me ask you, Ms. Nelson, I know that police, during the initial stop, essentially said, no worries, we're just checking you out. You've got some traffic capiases we're aware of, and depending on what the judge said, maybe we'll let you go, maybe we won't, something along those lines. Does that indicate that he's in custody?
I think a reasonable person would have thought that he was in custody in this situation. So that statement was, the context was, hey, we notice you have traffic capiases that we need. This doesn't mean you're going to jail or anything, we just need to check it out. He's in handcuffs at this moment and being escorted back to the police vehicle. That doesn't mean he's not going to jail. He's basically going to jail until he's cleared. So a reasonable person under this situation would certainly be feeling the pressure of a lengthy detention while he's being investigated to determine whether or not he's going to jail that night.
His car was also blocked in, so, I mean, granted, he was handcuffed, but he also couldn't have driven his car away, right?
Correct. His freedom of movement was substantially restricted in this case, unlike an ordinary traffic stop. Police approached his vehicle from head-on, which is quite unusual, and there was also a heavy police presence in this apartment complex vicinity at the time, separate and apart from this traffic stop. But once this traffic stop was initiated, several police on scene swarmed the vehicle. There were about 4 to 5 police that we can see from the body camera. So yes, it's an atypical traffic stop situation because of the way that police approached the vehicle and the fact that there was a heavy police presence involved. The heavy police presence also goes to the question of whether or not this was a non-intimidating or non-threatening situation, and I think that additional police presence does create a more intimidating situation where a person would not feel free to not speak. So that's sort of the issue here. Are we creating such a pressure situation where a defendant would know that they don't have to answer the police questions, or are they sort of subject to an environment where they feel like they have to forego their rights under the circumstances? And that's kind of exactly what happened in this situation. And I'd also like to bring up the question about is there anything in the vehicle if we have a drug dog sniff around the vehicle, is it going to hit on anything? That is tantamount to saying we're going to search your car in a thinly veiled way. We're going to have a drug dog determine whether or not you're lying to us because he had already denied the presence of anything being in his vehicle. So when we combine the fact that his movement was substantially restricted, there was a heavy police presence at the time that he was removed from the vehicle and escorted to the back of the police cruiser, and the thinly veiled threat of, we're going to search with a drug dog if you don't tell us what's happening inside the vehicle, those three things definitely create an air of being in custody for purposes of Miranda. And we think the trial court, under the circumstances of this case, erred in making the opposite determination, and we'd ask this court to reverse. If there are no further questions, I'll reserve the remainder of my time.
All right, and you will have 10 minutes
Okay, thank you.
remaining. Ms. Steer?
Good morning, Your Honor. Ms. Nelson, may it please the court. I think it's important to look back at Berkmer and Cleveland versus Olds, where the courts both said, both the United States Supreme Court and the Ohio Supreme Court said that there's not going to be a bright line rule for these kind of cases. And so Olds listed 3 different factors that we're supposed to look at. The first is whether the intrusion is minimal. The second is whether the questioning and detention are brief. And the third is whether the interaction is not threatening. I understand that the hurdle here that we have is that he was in handcuffs. This differs from some of the other cases where the question was whether or not, like in Olds, when the person was placed in the front seat, I think, of the police cruiser, and also in Ferris, when the defendant was placed in the front seat of the police cruiser but was not handcuffed.
Do you know of any case where a court found that somebody who was in handcuffs was not in custody?
I do not.
Okay.
I looked. I did not find any. However, I still think that this is something that there's still not a bright line rule, and I think that that even applies to when someone is handcuffed. And especially since the trial court specifically found in its decision that the handcuffs didn't exert so much pressure to threaten Bailey's right against self-incrimination.
But I thought the issue is whether a reasonable person in his situation would have felt free to leave. Isn't that what the question is?
Actually, I think in Olds, the Supreme Court actually got away from that a little bit, and they recognized that anytime someone is stopped by police, you're not going to feel so comfortable to leave, and so it's not a question about that. There's a difference between not feeling comfortable to leave and believing that you're in custody.
Yeah, but there's also a difference between if you asked, am I in custody? No, okay, I'm leaving. But here, they said, we handcuff you, that he's blocked in by officers, and you're not going to leave until we determine whether you can leave, right? I mean, that seems kind of different than somebody feeling like maybe they shouldn't leave. I mean, he couldn't leave.
He could not leave, that's true.
Right.
I think the fact that Officer, I'll butcher his name, Miucci, told him that he wasn't under arrest and that he was just trying to figure out whether or not he had to cite him. I think Ms. Nelson said that they were going to take him to jail regardless. On page 34 of the transcript, the officer says, no, we told him we're not sure we're going to have to take you to jail. We just have to see if we can recite you to court. So I think, he reassured him that he wasn't in custody.
But couldn't an officer always say that? I mean, maybe they've got a murder suspect at headquarters who they brought in handcuffs. They may say, hey, we're not sure we're going to arrest you yet. I mean, that doesn't answer the question, does it?
Sure, but it's again I feel like I'm
It's the
repeating Mr. Cummins. It's the totality of the circumstances.
As viewed by a reasonable person.
Correct. And here the trial court found that the totality of the circumstances found that he was not coerced to the point where his right of self-incrimination was threatened by the police actions. When you look at the...
But as Judge Krause pointed out, is that really the test? Isn't the test whether a reasonable person would believe they were in custody?
It is, yes. And I think that given the factors that the court was looking at, the fact that the officer told him he wasn't under arrest, that he wasn't, he was just checking his tickets. I think the fact that it was brief, that it was going to be brief. And that way it kind of differs from Ferris, because in Ferris, when they put him in the front seat, they said, we're going to search your car because we smell marijuana. There was no indication to him that they were going to. And also it was I know that there was a lot going on, but there's also the fact that even though there are a lot of police, this is also in public, which is, I think, one of the factors that Berkmer cited about in general as far as traffic stops, that there's not that feeling, there's not the risk of police coercion, or at least it's mitigated when it's in public as opposed to, them taking someone in a room or something like that. So that's one of the reasons why a traffic stop is different. And here, even though there were a lot of police around, it was still in public. There's less opportunity for the police to be coercive to him.
Was there any explanation? I mean, they found he had traffic capiases, and they knew that oftentimes they can recite somebody. Was there any explanation at the suppression hearing about why they handcuffed him?
They said it was because of the area they were going to. I believe that the two officers, Chiapponi and Miucci, I think that they were part of a gun task force that were in the area because there was a large group of people there, and they were actually there because they thought that there were some illegal drugs, and they also knew there to be guns in the area, and so they were concerned. I forget if it was Officer Miucci or Chiapponi, both of them testified, and I think they said that they had a lot of the shot spotter area action there in that area, so I think that was part of the problem. And so they decided for officer safety that they were going to handcuff him.
But he was surrounded by police officers, right? It wasn't like there was just one or two.
I'm trying to remember from the video whether he was, I know they pulled in front of him because he was pulling out and they went in front of him. I don't remember him being necessarily surrounded. I can't remember. I know that they were in a parking lot and that they were there because that's where the large group of people, so there might have been a large police presence there, but I don't know that they actually had his car pinned in. I'm sorry, I don't know if that, I can't remember from watching the video whether that's true or not.
Okay.
Unless the court has any other questions, we would ask that you have affirmed the trial court's decision. Thank you.
Thank you. Ms. Nelson, you have 10 minutes remaining.
I just don't want to mislead the court. My understanding of the body cam video, which is where I'm focusing on the statements to Mr. Bailey compared to the testimony at trial. I know that at the motion to suppress hearing, the officer testified in a way that he assured Mr. Bailey that he wasn't under arrest. But I don't think the body camera video statements really reflect that. Again, I think the body camera, from what I can hear from the video, says this doesn't mean you're going to jail or anything. That's not an affirmative, you're not under arrest, you're not going to jail. It's, hey, we have traffic capiases that we need to check out. That could result in you going to jail, but we need to check on that first. So I think a reasonable person under this situation, surrounded by police, because as far as I can tell from the body cam video, there were at least 4 around his vehicle at the time that he's being asked to step out, put in handcuffs, and walk to the back. So we do have a heavy police presence, and we do have this suggestion of incarceration, I'll put it that way. It's not an overt, you're going to jail, but it's also not an affirmative, you're not going to jail, everything's okay, we just need to check something out. It's not that clear, and I think a reasonable person under this situation would certainly believe themselves to be in custody, especially when you add the handcuff component. I think this case is distinguishable from Olds, the Cleveland v. Olds case that the state relies on. The 3 factors that they get at, the minimal intrusion, brief detention, non-threatening and non-intimidating circumstances, are not present in this case like they were in Olds. There was a pat-down search, he was handcuffed. There was an indication about searching the vehicle with respect to the drug sniff comment. So it's almost, it's analogous to what happened in Ferris. In Ferris, they said, is there anything in your vehicle? We're going to search the vehicle. And the defendant in that situation offered that he had paraphernalia. There was also a conversation about the smell of marijuana leading to that conversation. In this case, though, is there anything in the vehicle? No. At this point, this is not a drug investigation. This is just ascertaining whether or not he has, what's the nature of the traffic capias is. But then it goes into, well, if we have a drug dog sniff, is he going to hit on anything? That, I think, is analogous to we're going to search. From a reasonable person perspective, that's a search question. I know the case law is different on whether or not a drug sniff is actually a search, but we're talking about reasonable person standard here, not sophisticated legal minds under the circumstances. That also ties into whether or not this is a brief detention. Again, it's not an ordinary traffic stop. Where are you going? Did you know you were speeding, or did you know that your headlight was out? Let me run your license and registration and figure out, these next couple of steps. It's lengthened by the nature of investigating the traffic KPSs. It takes it out of the realm of an ordinary traffic stop into something more tantamount to an in-custody situation from a reasonable person perspective. Again, it's distinguishable from Olds. And lastly, the non-threatening, non-intimidation factor. I can't stress enough that I think the presence of heavy police presence in this case does take it into a more threatening, more intimidating, intimidating is probably more appropriate, but a more intimidating environment for somebody who is not free to leave. They have no control over their movements or what the police are about to do. They have to pursue this investigation. And again, whether a person is in custody, whether they believe that they're in custody, does have this component of whether or not they feel free to not engage with the police in the way that police want them to. So does he feel free to keep quiet, to keep to himself, to not answer police questions? And I think the circumstances in this case are threatening enough and suggestive enough of an arrest where he would believe he was in custody for police purposes. With respect to the officer safety component to the handcuffs, I think that that's irrelevant to the reasonable person standard. Certainly officers can perhaps put a driver in handcuffs for officer safety, but the question is a reasonable person in this situation going to believe that they're in custody? And I think the presence of handcuffs pushes us more toward an in-custody finding. I know I just rambled a lot. Does the court have any other questions?
But, yeah, this may be irrelevant. I may be mixing up videos, but during the stop, was there also what sounded to me to be a large canine barking in the background? I might be confusing videos, and if you don't recall that,
I don't recall that, to be honest.
Okay.
But there is.
I heard dog barking, but I might be mixing up videos.
Sure. No, I honestly don't recall that.
Okay. All right.
If I did, I probably would have emphasized that. No. But no, but he did say it. I mean, there is like a notion, and maybe
It didn't sound like a chihuahua or anything.
No, right? No.
It sounded big. Okay. I might be mixing videos. Okay.
If there are no further questions, we just ask that you reverse. Thank you.
Thank you.
Thank you. Thank you both very much for your arguments this morning. We will take this case under submission, give you a timely written opinion, and that will conclude arguments this morning for the First District Court of Appeals.
Yeah.